You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 55, How to Respond to an Election of Species Requirement. My name is Dr. Adam Diamond, registered patent attorney and founder and owner of Diamond Patent Law in Los Angeles, California. I can be contacted through my website at diamondpatentlaw.com, that's DIAMENT, patentlaw.com, or if that's too hard to remember, you can get to it through patentingforinventors.com, that's patentingforinventors.com, or call me at 424-281-0162. And while most attorneys can only practice in states where they're members of that state's bar, patent attorneys are actually allowed to practice patent law in any state. So feel free to contact me regardless of where you live. In the last episode, I talked about a restriction requirement. A restriction requirement is when the examiner believes that you have more than one invention in your application, and you have to restrict it to just one invention to be examined first. There's a similar kind of requirement that you'll often see, and they're kind of put side by side, and that's called an election of species requirement. In an election of species requirement, the examiner isn't saying that you have more than one invention. What he's saying is that you have too many variations of the same invention, and it would be too difficult to review all these variations if the overall broadest version of your invention isn't allowed. So, what does this mean in the real world? And I'm going to do just a couple of hypotheticals. Let's say that you were the first person to come up with a flashlight. Your first claim maybe said, I claim a device having a bulb, a battery connected to the bulb, and a housing for the batteries, and a switch to turn on the bulb. That would be just a very broad, independent claim. You know, it might be worded differently in the real world, but it's just the gist of it. Then in the first dependent claim, you say, the flashlight of claim 1, where the housing is transparent. So in this case, you're referring to your invention so that if your broad claim doesn't get allowed of a general flashlight, then maybe the examiner will allow your invention if it's a see-through, transparent housing. Let's say claim 3 is the flashlight of claim 1, where the housing is opaque. So this is probably your standard flashlight where it's not see-through. And for whatever reason, you put both dependent claims in because you thought, well, maybe the first claim was too broad, but the examiner will allow it if I start going into details about how the housing looks. So in the dependent claims, you have two opposite claims. Now this is kind of important because you'll often get an election of species requirement if you have dependent claims that are opposite of each other. So when you get an election of species requirement, what the examiner is saying is, I'll examine your first broad claim, but if I don't allow it, I'm not going to examine every little variation of it. Now, according to the rules, the examiner is still supposed to review a reasonable number of species if it's not unduly extensive and burdensome. Now, what the examiner is going to do is look at all your figures, and let's say that figures 1 are one version, and let's say figures 1 through 5 are one version, and figures 6 through 10 are a different version. The examiner is going to say that it looks like figures 1 through 5 are of one species, and he'll call that species 1, and figures 6 through 10 are a different species, and he'll call that species 2. In our example, let's say the first 5 show a transparent flashlight, and the other 5 figures, they show an opaque flashlight. And he's going to tell you that it looks like figures 1 through 5 read on to claims 2, and figures 6 through 10 read on to claim 3, and you must elect a species. Now, you can fight the examiner about whether he's right about forcing you to elect a species, but I'd actually caution you against that because it's possible it could come back to bite you in the foot. Since this is just an introduction to election of species, I'm not going to go into that, but I would just caution you not to fight it, and this means you answer what's called without traverse. What's better to do in the response is just pick one version that you think is most commercially viable or you think has the best chance of allowance. So let's say you think the transparent version will be more patentable and that the one that and also the one that you're thinking about commercializing. You will respond to the office action and say, applicant elects species 1, which reads onto claims 2 and also figures 1 through 5. Now, this is what's important and different about election of species compared to restriction. The examiner is still going to examine your broad claim that mentions nothing about being transparent or opaque. If the examiner allows that broad claim, and this broad claim is called the generic claim, then you have patent protection for all kinds of housing, whether it's transparent or opaque, because your claim is silent on that issue. When your patent is granted, all your dependent claims will be there because the examiner didn't need to examine them at all. In patent speak, once the generic claim is allowed, the species that depend on the generic claim should also be allowed. But if the examiner felt like your general flashlight wasn't patentable, he's going to go on to the claims that you elected and look to Claim 2. If the examiner finds that your transparent housing flashlight is patentable, then that's what you'll get a patent for, but you'll have no protection for opaque housing. Now you can file another application to cover your opaque housing flashlight, what's called a continuation patent application, which I'll go over in another episode. So what are some things you might get an election of species for? You might get an election of species if you have a lot of different claims that just talk about different materials. Let's say that you were the first person to try to patent a light bulb, and your first claim was a device having a transparent shell and a filament capable of emitting light when an electric current passes through the filament. Now, I know that there's more to light bulbs than just a shell and filament, but I'm just trying to keep it simple. In dependent claims, and you might have in Claim 2, the device of Claim 1 where the filament is a tungsten filament. Claim 3 maybe says the device of Claim 1 where the filament is a carbon filament. Claim 4 maybe says the device of Claim 1 wherein the filament is a bamboo filament. And it can go on and on. Let's say you had 50 claims and you just went and listed 50 different materials that really aren't related to each other. If your first general claim doesn't get allowed, then the examiner is going to have to do 50 more searches for different materials, and the examiner doesn't want to do that. So the examiner is going to issue an election of species requirement. Now maybe the examiner will be a little lenient and say that he'll group the filaments into metal filaments and vegetative filaments, and there will be 2 species. Maybe the examiner will say that there are 50 species, and you have to elect one of species 1 through 50. So you think that the one that's going to mostly be used is tungsten filament. So you elect species 1, and that's Claim 2. So the examiner is going to review your claims and find that Claim 1, the shell and filament that emits light, is already in existence, and that someone's already came up with a bamboo filament for a light bulb. So the examiner rejects your claims as not being novel. Now the examiner will look to Claim 2 because that's what you elected. The examiner finds that a tungsten filament, which has never been done before and is new and non-obvious, so we'll give you a patent for that. So you'll get a patent just for the version of the tungsten filament. Now I'm assuming that tungsten filaments, haven't been invented yet, but we all know that they already have been. But this is just an example, let's say, of an early early light bulb. So what if you had elected Claim 4? That the claim said a bamboo filament. The examiner would examine Claim 1 and reject it because you elected Claim 4, the examiner will reject that claim and say it's not new. Now you can't go back and say, oh wait, I see that tungsten is really the cool inventive thing. I want you to go back and review that claim. Well, you can't do that because you elected Claim 4. But what you can do is file a new application with the tungsten filament claim, and then you'll have that new application examined. And you would just have to abandon your first application. So to review, a restriction is when the examiner says that you have more than one invention and will only examine one invention. These inventions will have different independent claims. For an election of species, you basically have to decide which dependent claims you want the examiner to review if your independent claim is rejected. You have to select one or sometimes a few groupings of variations called species of your invention that you'll want the examiner to examine should the broad claim be rejected. You'll also say what claims they are, and you'll usually also have to say what figures go with that set of claims that you want examined. Restriction and election of species practice can be a little tricky, and there are several ways to handle it, but I just wanted to give you guys the gist of what it means. For example, sometimes it does happen where the species can be independent inventions, or they can be related inventions, and basically the examiner doesn't want to go overboard in searching for prior art for different inventions or versions of inventions, and wants to speed things up by making you narrow down what the examiner is supposed to examine. Later, you can decide in a new application if you want to try to get patent protection for the versions of your invention that you didn't get allowed. Now, if you want help with your patent application, you can contact me through my website at patentingforinventors.com. That's patentingforinventors.com, or call Diamond Patent Law at 424-281-0162. I'm Adam Diamond, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamond. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamond at patentingforinventors.com. That's patentingforinventors.com, or call Diamond Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.